Can you fight a trust in court? If you think that your loved one's wishes are not reflected in the terms of their trust document or the way it's being distributed and managed, you may have the right to challenge that trust in court. However, only certain individuals can fight a trust, and even then, only on specific grounds. Here we're going to take a look at what you can do to protect your loved one's estate and ensure that their final wishes for their legacy are correctly carried out. If you have questions, schedule a free consultation online at rmolawyers.com. Do I have to go to court to contest a trust? Yes. To contest any aspect of a trust, most likely you're going to need to file suit in probate court. That does not necessarily mean that you can't settle the case before or after you file your case. However, to formally challenge any part of the trust, you're going to need to start a lawsuit. This is a point of confusion for many frustrated beneficiaries. But let's pull no punches here. If you don't file suit in court by whatever deadline applies to your claim, in almost all instances, is going to be lost forever. So to pursue your claims, you're going to need to have legal standing to challenge a trust in court, simply meaning that you need to have a financial stake in the outcome of that trust in that dispute. This doesn't necessarily mean that you're going to have to be listed as a beneficiary though. Even if you're an heir, or you can show that you were listed on a previous version of the trust, then most likely the court's going to find that you have standing to file suit. There are various ways to show that you have a financial stake in the trust or its distributions. First, you can be a beneficiary, someone who receives a distribution from the trust. You can be explicitly named or fall into a group of defined beneficiaries, such as all of my kids, all of my grandchildren, etc. But legal standing is a murkier issue if you're not named as a beneficiary. One way to show a financial interest is to prove you would typically inherit some of your loved one's assets, for instance, because you're their child. Another method is to show you were a beneficiary in a prior version of the document, either pre-amendment or new document's creation, and were left out of the current iteration. Finally, you can argue in court that your loved one intended to leave an inheritance, but for some reason their trust simply doesn't list you as a beneficiary. Although these claims really aren't trust contests, as much as they're promissory estoppel claims, which is something that's beyond this discussion today. Do most trust disputes go to court? Because you must file a formal lawsuit to dispute a trust, contests normally at least start in court. However, once you've started that case and filed your petition, the trustee, their attorneys, the other beneficiaries, and you and your trust and estate litigation lawyer can always negotiate a resolution, either informally or through a formal settlement process like a settlement conference or mediation. And sometimes it's even possible to resolve a case before you even file suit. Every case rises and falls on its own set of facts. And if you have a trust dispute, you'd be well advised to consult an experienced trust litigation attorney who can help you. How do you challenge a trust? Challenging a trust requires you to have legal standing and valid grounds to file a petition in court. A successful challenge will invalidate provisions or entire documents and leave the estate in the position that you believe your loved one intended. There are various grounds on which you can legally challenge a trust. Some of them include undue influence, lack of capacity, fraud, forgery, mistake, among others. Often, for many of these claims, issues surrounding your loved one's state of mind when they created the document you're challenging are going to need to be reviewed. Taking a look at capacity can be a complicated legal inquiry that involves medical records and other evidence, and digging into those issues often can be emotionally trying for clients and their families. Before you decide to contest a trust or a trust amendment, you should talk to a knowledgeable trust litigation attorney. They should be able to help explain the law and what you need to prove your case in order to succeed. A trust litigation lawyer also can guide you and other family members through the process of gathering documents and other evidence that you're going to use in those legal proceedings, as well as explain the process, costs, and potential outcomes, so you know not only what you can expect, but when and for how much. Have questions? At RMO, we protect people like you every day. Give us a call, shoot us an email, or schedule a free consultation at our website, rmolawyers.com. Thanks for watching.